India is the highest legal penalty for crimes under the country's main substantive penal legislation, the Bharatiya Nyaya Sanhita, formerly the Indian Penal Code or the IPC, as well as other laws. Executions are carried out by hanging as the primary method of execution per section 354 into brackets 5 of the CPC 1973, which says hanging by the neck until dead and is imposed only in the rarest of rare cases. Currently, there are about 539 prisoners on death row in India. The most recent executions in India took place in March 2020, when 4 of the 2012 Delhi gang rape and murder perpetrators were executed at the Tihar jail in Delhi. In the Code of Criminal Procedure, CRPC 1898, death was the default punishment for murder and required the concerned judges to give reasons in their judgment if they wanted to give life imprisonment instead. By an amendment to the CRPC in 1955, the requirement of written reasons for not imposing the death penalty was removed, reflecting no legislative preference between the two punishments. In 1973, when the CRPC was amended further, life imprisonment became the norm and the death penalty was to be imposed only in exceptional cases, particularly if a heinous crime committed deems the perpetrator too dangerous to even be considered for parole release into society after 20 years. Life imprisonment without parole does not exist in India since it is too expensive to freely feed and house dangerous criminals all their lives, and eliminating the possibility of parole after a life sentence removes the positive and rehabilitative incentive to improve behavior. All criminals sentenced to life imprisonment in India are automatically eligible for parole after serving 20 years, as per IPC section 57, and required special reasons. This significant change indicated a desire to limit the imposition of the death penalty in India. The CRPC 1973 also bifurcated a criminal trial into 2 stages, with separate hearings, one for conviction and the other for sentences. Before India gained independence in 1947, the British colonial judicial system was heavily biased in favor of Europeans, particularly the British. The laws under the British Raj, such as the Indian Penal Code of 1860 and various legal precedents, often treated white offenders with leniency compared to Indian defendants. In cases where a white person, especially a British national, was accused of murdering an Indian, the legal system often worked to protect them. Juries, which were often composed of Europeans or those sympathetic to the British, rarely convicted white perpetrators for crimes against Indians. Even when convicted, sentences were typically reduced or commuted, making it extremely rare, if not unheard of, for a white person to be executed for killing an Indian under British rule. One of the most infamous cases highlighting this racial bias was the trial of Reginald Dyer, responsible for the Jallianwala Bagh massacre in 1919, where hundreds of unarmed Indians were killed. Though Dyer's actions were widely condemned, he was not criminally prosecuted but merely removed from service. Similarly, other cases of violence against Indians by British officials or civilians often resulted in light punishments or no consequences at all. Given this context, there is no recorded instance of a white person being sentenced to death in British India for murdering an Indian, as the colonial legal system was designed to uphold racial privilege rather than dispense impartial justice. After the completion of proceedings as prescribed by the Code of Criminal Procedure (CRPC), the trial magistrate or judge pronounces the judgment in the case under Section 235. In case of conviction of the accused, there shall be a mandatory pre-sentencing hearing as according to Section 235 into brackets 2, CRPC again. The CRPC 1973 also contains a provision regarding special reason for a death sentence, which is Section 354 into brackets 3. The code also provides that the court must record special reasons justifying the sentence and state as to why an alternative sentence would not meet the ends of justice in the case, according to the principle. Life imprisonment is the rule and the death sentence is the exception. After the decision and sentencing by the Court of Sessions, the trial court, a High Court needs to confirm it for the death sentence to be valid. The High Court may confirm the death sentence awarded by the Court of Sessions, pass any other sentence warranted by law, annul the conviction, convict the person of any offence for which the Court of Sessions, trial court again, might have convicted them under a new trial, might have convicted them, order a new trial on the same or amended charges, or acquit the accused person under Section 368 of the CRPC. The High Court may also enhance the sentence awarded by the Court of Sessions to a death sentence according to Section 386 into bracket C. The High Court shall not enhance the sentence awarded to the accused without giving them a reasonable opportunity of showing cause against such enhancement. And whilst showing such cause, the accused may even plead for acquittal or reduction of sentence awarded by the Court of Sessions. Additionally, the state government or the central government under Section 377 of the CRPC may direct the public prosecutor to appeal to the High Court against the sentence granted by the Court of Session on grounds of inadequacy, further exercising its suo motu revisional powers under Section 397, read with Section 401. The High Court may even, in the absence of an appeal, enhance the sentence awarded by the Court of Session. The High Court may also, in accordance with Section 367 of the Code of Conduct, or direct further inquiry into or additional evidence to be taken on any point bearing upon the guilt or innocence of the convicted person. Unless directed by the High Court, the accused need not be present during this period of this inquiry or when additional evidence is taken. The High Court also has the power under Section 407 to withdraw a case pending before a subordinate court and conduct the trial itself, and may award the sentence of death on its own. After the death sentence is confirmed by the High Court, an appeal by special leave petition SLP under Article 136 of the Constitution may be filed. The Supreme Court may, in its discretion, after considering the issues, grant special leave to appeal under Article 146 of the Constitution. Exercising its power under Article 136, the Supreme Court decides whether the special leave petition deserves to be heard as an appeal. Correcting an earlier trend of dismissal of SLPs involving the death sentence, in limine dismissal of special leave petition at the threshold without giving any detailed reasons, now they are automatically granted. A petition seeking review of a judgment or order passed by the Supreme Court may be filed under Article 137 of the Constitution before the Supreme Court within 30 days from the date of such judgment or order. The Supreme Court may allow a curative petition to reconsider its judgment or order if it is established that there was a violation of principle of natural justice or apprehension of bias on part of a judge. 72 of the Constitution, the President of India has the power to grant pardons and to suspend, remit, or commute sentences in certain cases. The President may consider the case of the convict and may pardon the death sentence. The Governor cannot pardon a death sentence. The Governor can only suspend, remit, or commute a death sentence under Article 161 of the Constitution of India. Supervening circumstances which should be considered during mercy petitions, such as mental illness, insanity, trauma, solitary confinement, etc. The list is inexhaustive. In cases where the death sentence is awarded, Form number 42 in the second schedule of the Code of Criminal Procedure, 1973, contains the form of the death warrant or black warrant. It is addressed to the superintendent of the relevant prison, who is supposed to return the warrant to the court after certifying that the death sentence has been carried out. If a session court issues a death warrant before the end of judicial and administrative process appeals, it would amount to a serious violation of the law. The convict should be allowed to exhaust all the legal remedies available, such as appeals, review, and mercy petitions, before the black warrant or the death warrant is signed. The guidelines given are needed to be followed before issuing the death warrant. Hanging is an ancient method of execution, which was a part of the Roman law, Anglo-Saxon law, English law, French law, and German law. Hanging as a punishment was a prevalent and standard mode of execution until the abolition of capital punishment in the United Kingdom in 1965. This traditional method of execution may involve suspending the convict from a gallows or crossbeam until death occurs from asphyxia. Or it may be that the condemned person stands on a trapdoor, and when the trap is released, he falls a couple of meters until stopped by the rope tied around his neck, or a knot in the noose helps jerk back the victim's head sharply, enough to break the neck. This mode of execution is widely debated, and the Law Commission, in its report in 2015, stated that the shift from hanging to more advanced methods of execution must be made in India. Apart from hanging, the other method of execution and allowed under the Indian law is shooting, which is provided for under the Army Act, Navy Act, and Air Force Act. Section 34 of the Air Force Act 1950 empowers the court martial to impose the death sentence for the offenses mentioned in Section 34A20 of the Air Force Act 1950. It is at the discretion of the court martial whether the method is by hanging or shooting. The Army and Navy Acts have similar provisions. Death penalty in India also laid down an elaborate sentencing framework requiring sentencing judges to impose the punishment only in the rarest of rare cases. The rarest of rare doctrine developed in Bachan Singh requires the judge to balance aggravating and mitigating circumstances while determining whether a death sentence is appropriate. Thereafter, it listed 5 categories of the cases where the death sentence is appropriate. Firstly, the manner in which the crime was committed. We're going to just talk about murder, but it applies to other cases. Murder committed in an extremely brutal, grotesque, diabolical, revolting, or drastic manner, so as to arouse intense and extreme indignation of the community. Secondly, motive behind the criminal act. Murder committed for a motive which evinces total depravity and meanness. Thirdly, the nature of the crime. Murder that would arouse social wrath, like homicide of a person belonging to a special caste or special tribe, or a minority community, a death related to dowry, etc. Fourthly, the degree of the crime. Multiple murders of a family or a large number of persons of a particular caste, community, or locality. And finally, the status of the victim. Murder of an innocent child or a helpless woman or a person rendered helpless by old age or infirmity. Murder of a person by the murderer who is in a position of domination or of trust, or murder of a public figure generally loved and respected by the community for the services rendered by him, and the murder is committed for political or similar reasons other than personal reasons. It focused more on the crime factors or adopted a crime centric approach on the sentencing policy of the death sentence. Furthermore, it moved towards the practice of balancing aggravating and mitigating circumstances to impose the death sentence. Where the Bachan Singh judgment mandated that the death sentence be imposed where life imprisonment is unquestionably foreclosed. Thus, this precedent and subsequent line of cases has systematically permitted the justification of the death sentence on the manner, nature, and gravity of the crime, without taking into account circumstances of the criminal in order to exercise judicial discretion on the death. Sorry, another case again. In Ashok de Burma versus State of Tripura, March 2014, the Supreme Court commuted the death sentence to life imprisonment with a minimum of 20 years. It introduced the concept of residual doubt as a mitigating circumstance in Indian sentencing jurisprudence. The court stated that there could be a state of lingering uncertainty that exists beyond reasonable doubt but below absolute certainty. In 2019, the Supreme Court reiterated the residual doubt principle of Ashok de Burma in a case called Ravi Shankar versus State of Madhya Pradesh, October 2019, and held that it creates a higher standard of proof over and above the beyond reasonable doubt threshold in order to sentence someone to death. Prisons and other government departments don't have accurate records of the number of persons executed in India. An absolute lack of coordination among different official sources has hindered the collection of accurate data on the subject. Despite these limitations, Project 39A has attempted to create a list of people executed in India. This number is, however, significantly lower than the actual number of people executed as per data from the Law Commission of India's 35th report, which states a number above 1,000 between the years 1947 to 1967, 20 years of independence. This fact highlights broader issues with data collection in India's criminal justice system, as the country lacks comprehensive records of individuals who have been sentenced to death. A few cases of people that were executed. On 27th April 1995, Otto Shankar was hanged in Salem Central Jail at Salem, Tamil Nadu for the murder of 6 people. On 27th May 1997, Kamta Prasad Tiwari was hanged in Jabalpur Central Jail for raping and murdering an 8-year-old girl in 1991. On 14th August 2004, at Arbori Central Jail, Dhananjoy Chatterjee was hanged for the murder following a rape of an 18-year-old called Ethel Payak at her apartment residence in Baudnapure, West Bengal on 5th March 1990. While the mercy petition of Chatterjee was pending before President Abdul Kalam, support for the rejection of the mercy petition as well as his execution was drummed up in West Bengal by various political groups and organizations. The mercy plea was rejected on 4th August 2004. Before the execution of Ajmal Kasab, due to his role in the 26/11 terrorist attacks, people from across the globe wrote to President Pranab Mukherjee to inform his family and the public of the rejection of the mercy petition and about any scheduled date of execution. Kasab was hanged in secret on 21st November 2012 in Yarwada Central Prison. Afzal Guru was convicted of conspiracy in connection with the 2001 Indian Parliament attack and was hanged on 9th February 2013 at Delhi's Tihar Central Prison. The Supreme Court of India upheld the sentence on August 4th, 2005, ruling that the attack shocked the conscience of society at large. Afzal was scheduled to be executed on 20th October 2006, but the sentence was stayed. Yaqub Memon, convicted of 1993 Bombay bombings, was hanged in Nagpur Central Jail at Nagpur on 30th July 2015. On 21st March 2013, the Supreme Court confirmed Memon's conviction and death sentence for conspiracy through financing the attacks. On July 30th, 2013, the Supreme Court rejected Memon's application for an oral hearing and dismissed his review petition circulation. President Pranab Mukherjee rejected Memon's petition for clemency on 11th April 2014. Memon then filed a curative petition to the Supreme Court, which was rejected on 21st July 2015. All the terrorists are Islamic. The four adult perpetrators, Mukesh Singh, Akshay Thakur, Vinay Sharma, and Pawan Gupta, of the Delhi gang rape and murder case, the Nirbhaya case, who survived the trial, were hanged at 5:30 a.m. on 20th March 2020 at Tihar Central Prison in Delhi after a lengthy legal battle. Cases of executed inmates are typically handled as follows. Firstly, they're either handed over to the family after execution. The prison authority's duty is to inform an inmate's family of the execution. If the family claims the body, it is handed over to them for last rites and burial or cremation according to their religious customs. If the family does not claim the body within a stipulated time, the prison administration performs the last rites. The body may be buried or cremated as per general procedures, followed by the prison. Autopsy and medical examination is a must to be done before the body is cremated or buried so that the cause of death can be confirmed. Finally, if a body is unclaimed, it can be handed over to the medical department for research purposes. And in special high-profile cases where security concerns exist, the authorities may choose to conduct the funeral privately or in secrecy to prevent public disorder. Anyway, I hope that you've enjoyed this video. As usual, please like, share, subscribe. Many people watch my videos, but you don't subscribe. Help me grow. Thank you.